Immigration policy changes every day. Careers, businesses, and families are all at risk. You need to stay informed. We can help. Welcome to this week's episode of the Immigration Podcast.
Well, hello and welcome to what will be episode 11 of the Immigration Podcast. My name is Rob Ratliff. I'm a former immigration judge and an immigration attorney in Cleveland, Ohio. And with me today is
Susan Hiller, former DHS counsel for Immigration and Customs Enforcement, Department of Homeland Security, and with Hiller Law Group.
Excellent. And soon we'll be joined by one of our co-hosts, Anis Saleh, who's an immigration attorney in Syracuse, New York, and I'll butcher his name, and we'll let him introduce himself when he gets in here. So, Susan, been reading a lot about ICE coming to your town.
Yep. Apparently, Border Patrol is on their way, and so they will be in the Charlotte, North Carolina Charlotte, North Carolina. So I expect a lot of habeas petitions are going to need to be filed because they don't always make the correct decisions in enforcement.
Yeah, now that they've solved all the problems in Chicago and there's no more problems there, time for them to move on, I suppose. But yeah, the habeas actions are going to be prevalent. But there's been a lot of good movement. I don't know if you've seen some of the decisions, but especially out of the 11th Circuit, there's been a lot of good district court decisions in habeas actions with respect to mandatory detention and things like that. And that's been really good.
That's really good for the 11th Circuit. I actually haven't read those. I need to get up on those. I have heard that in Chicago, a federal judge as Border Patrol's leaving, a federal judge is just granted a bunch of habeas petitions as well.
Yeah, and by and large, what most of those decisions I've read recently have said is that this whole mandatory detention scheme is just it just doesn't fly. It ignores various parts of the Immigration and Nationality Act. It creates problems because it conflicts with the Lake and Riley Act, which kind of started the role of all this mandatory detention. So I think most of those federal decisions are on the right path. So it's going to be helpful to clients eventually.
Yeah, that's going to be really interesting to see. I think North Carolina should be very similar. And if we end up going to the 4th Circuit, hi, Anis.
Hey guys, how you doing?
Good.
Forgive me if I have my camera off today.
Oh, okay.
No, welcome.
I'm not as handsome as Rob.
No, we've seen you, Anis. You can't.
It's been a long day for him.
You can't say that.
How you guys doing?
Good. How are you?
Crazy world we live in, right?
Yeah. We were just talking about the recent reports of ICE is now heading down to North Carolina and be in Susan's area.
Yep, Charlotte. They're coming to Charlotte. It's actually not ICE. Well, ICE is here already, right? But Border Patrol. They're sending Border Patrol here, and to enforce the immigration laws. And I'm sure ICE obviously is with them, but we have ICE here, so they may be bringing some detailed people with them, I guess.
What I've noticed though, I was really wondering to ask you guys. I've noticed they're so overwhelmed. They're making like ridiculous mistakes. Like I had one today. I mean, they literally replaced all the factual allegations, and they said in lieu of all factual allegations, and they just put one allegation. And even the judge was frustrated with them. And I mean, I think the judges are even pushing back now. They're just saying, what are we doing here?
Yeah.
This is the federal district court or the immigration judge?
Immigration judge. So what happened in this case was first they didn't give an I-602 waiver opportunity. So that's a termination. But two, they're charging wrong charges. They're charging inadmissibility and deportability. Then they file an I-261. And instead of putting in addition or in lieu of number 2, it replaces number 2. No, he just put in lieu of all stated charges in the original charge, and just lists one factual allegation. And it's not even that big of a deal. I mean, you could just say, OPLA, ICE at any time can do an I-261. You should have just orally amended.
You can orally amend it. You can do a 261 at any time, but I'm confused. Like, one allegation, is the allegation just you are not a U.S. citizen or U.S. national? Is that
Not even that? Not even that. So they say that he was admitted. He's a refugee. He's admitted. So the burden's on the government, not me,
Right.
by clear and convincing evidence because he's an admitted alien.
Right.
So what they did was they messed up because he's Palestinian stateless, but was born in Iraq. So they put he was a Iraqi citizen. So that was wrong. So they fixed it and just said he's an Iraqi native, which is still wrong, but an Israel or Palestinian citizen. But he put that one charge, but he, instead of putting in addition to or in lieu of that one charge, he put in lieu of all charges, all factual allegations.
So they don't know how to. So the people doing the I-261s don't know what they're doing either. It sounds like.
Exactly. So I told the judge, Your Honor, I can't even respond here. I mean, the factual allegations is he's from one place, but you didn't even say that he's a U.S. citizen or national. You didn't even say you don't even have the allegations anymore for the removability charge.
Yeah, that I would just ask him. Did you ask him to terminate it because they don't know what they are not ready to proceed?
Yeah. See, the one thing about it is a detained case. Now, I know the rule of the I-261 that you could do it at any time. I'm surprised they didn't do it. But I had a better argument because, if I ask him to terminate, he'll just say I amend, right? But the termination that was happening was we went to a refugee adjustment application. And I look in there and I see the supervisor on a Friday giving an interview. So I knew we're getting NTA'd, and I see the FBI guys and the ICE guys in the back, and they made a big critical mistake. So I held the I-602. I didn't file it at the interview because I wanted them to make a mistake. You have to have a right to tell me what the inadmissibility is, and then I have a right to file an I-602. Instead, they pretended like, they might approve it, they might not. They never told me any inadmissibility, and then said, what are your I-602 things? So I said, well, if we file an I-602, this is what we do. So what they do then is literally deny everything, which is against the UCIS policy manual that says you have to be able to file a 602. The only way you don't have to file it is if the officer approves it, right? So now it's a big mistake because in the detention proceedings, in the removal proceedings, I have a right to renew that refugee application and the waiver, but I can't renew it because I never filed it, and they never gave me an opportunity. So now he said, put it in writing, put it in a motion, I'll reset it in the detained case. And the judges really wanted to terminate, but I'm interested in Robin and you. You think the judge just didn't terminate it because he just wants something to fall back on?
Well,
What do you mean?
I think there's a lot of judges that are just scared, and they're going to bend over backwards to accommodate some of the mistakes and confusion we're seeing. I seen an NTA today that just was clear, just full of cut and paste errors. I mean, it was barely legible because sentences were all out of place and out of whack. But I think in every case, the judge is just going to reset and allow an opportunity for DHS to brief or to correct. So I think you gotta have to be prepared for that.
Yeah, this is not normal because you have a right to do an I-261 at any time, but you can't just keep doing I-261s. Like judges have enough at a point where they're like, you know what, get your act together, government. I mean, I can say that I was the government, but get your act together, government. You don't know what you're doing. You don't know which way you're going. Then then terminate it. They can terminate it without prejudice. So you can re-bring it when you're ready, assuming they are removable. Because maybe the fact is, like you said, Honest, they didn't allege they're not a U.S. citizen or U.S. national. Maybe they're a U.S. citizen or U.S. national. They have to allege that in order for them to be removable. So,
and yeah, in the I-261, I've made arguments before. If you read the regulation, it says you can add and expand, but it doesn't say that you can withdraw and then replace and then put back.
wait a minute. What do you mean by? Are you talking about the 2?
So 261, if you read the regulation in the statute, regulation says you can add, supplement, but it doesn't say that I can remove and then put back.
Yeah, I've never had to do that, because when I have added or removed things or said in lieu of, that's removing them. It's to make a correction based on the fact that the Border Patrol or ICE or USCIS messed up. Like, if we don't have proof where they entered, I'm not alleging that. I'm alleging unknown. I would change it all the time, because the burden isn't on us, on the government, I should say, in an EWI case to prove time, place, and manner of entry. And I would put the burden back onto the respondent and respondent's counsel. If we don't know exactly where you entered, why are we putting a location? Unless we saw them enter at Houston, just because they say Houston, Texas, if we encounter them in the interior, we shouldn't be putting that down. So I would always change that. But I never had to go back, because as an attorney, when you're redoing things, you're looking for factual allegations. Factual. That means I have to have facts to back up what I'm saying. And why, as an attorney of law, would I have to correct a correction? Because my correction, based on ethics, unless I made a mistake, but 99% of the time, I've never had to do that, because the only time I ever had to do that, Anas, is when I put unknown based on the fact that the person said they were admitted to the United States, but there was nothing we could find in the computer system. So if I had to go back, it was based on them finding their I-94. This is back in the day when they didn't have the I-94 tracking system better. But if we couldn't find it in the was called NICE, the non-immigrant information system, if I couldn't find it in there, and then eventually they find their I-94 and I'm able to put that I-94 number in and find them, then that would be the only time I would go back. But it was to benefit them, so they weren't against that, because they wanted to adjust their status.
Well, but under the current policies now, we've got a whole bunch of people that are writing these NTAs that many of them have never done it before. I mean, we've got them issuing day of NTAs at USCIS denials. There's nobody there at that USCIS denial time that has a ton of experience issuing NTAs. I mean, that's something that always, got handled someplace else. So we've got all these people now issuing these NTAs, and they don't necessarily know what's supposed to be in it, or what specific charges or allegations or grounds of removability apply in each of these situations. So you've got to look at every one now, especially the ones that are coming out of USCIS immediately after these hearings, just like Anas just had. The chances of them being right are pretty slim.
Well, that's sad. You know why, Rob and Anas? Because the Office of Principal Legal Advisor, the attorneys for ICE, who represent Department of Homeland Security, at least, as of 2022, we were reviewing all of the notice to appear. We were not allowing them. I can't say always prior to that, but like during the last, like 2020, 2022, 2021, going back to probably maybe 2018 or so, we were reviewing every single NTA before it was filed in court. It was not allowed to be filed in court unless it was correct. We weren't even doing 261s. At that point, we were sending them back, because we would spend way too much time if we had to amend all those. So we would send them back. USCIS was notorious for having problems. Of course, Border Patrol was horrible. Sometimes they were standard, so they were fine, the Border Patrol ones, but the ones that were bad were very bad.
Yeah. Well, and in all fairness to all the OPLA and DHS attorneys, I mean, this wave of detention and the new guidelines for processing cases, they haven't staffed up. I mean, they're still running the same numbers they had a year or 2 years ago, with minimal office support.
Yep.
So, I mean, they're just overwhelmed just as much as defense attorneys are, and even the courts.
They're probably way more overwhelmed. I have never been so overwhelmed as I was working for Opla the last 10 years I worked for them. The amount of work is insurmountable. The budgeting is never for extra attorneys. It's always for more judges. But we have no paralegals. We do all the photocopying. We do all the evidence. We do everything. We have clerks that would pull files and get files or do phone calls or deal with mail. But that was a full-time job for them. Like for us, we had to scan decisions in. We did have one scanning clerk at a time, but the amount of things that are expected from the statistical point of putting things in Planet for stats to go to Congress takes so much work, and that, getting to the actual legal work and it's overwhelming. I mean, it's overwhelming. Duty attorney, the amount of work you get being duty attorney can last for an entire week, and then you're duty attorney again, while you're also going to court, litigating, trying to do everything the judge asks you to do with no support staff, to help you with that.
Yeah. Well, and I don't know what's going on. I just received word this week from Ohio AILA, the American Immigration Lawyers, from Ohio AILA, that our local OPLA office was no longer going to be providing us the assignment schedule. So normally they're assigning OPLA attorneys to cases 60 to 90 days out from the case, which is I think a lot of people don't understand is that the OPLA attorney, it's almost like a public defender. The old joke about public defenders, you get to file on the way into court. And for OPLA attorneys, it's pretty close to that a lot of times. Mm-hmm. And but they used to provide the duty schedule. So, if you have a trial coming up in 2 months, who's going to be assigned to that judge on that day. You could reach out in advance and try to see if there's something that can be worked out. But they're not releasing that anymore. So I think part of that's because they don't know who's going to be there.
Yeah, but you know what, Rob? Remember we had that problem before with the primary versus the non-primary, and I made that big argument to one of the judges. I said, listen, at the end of the day, the chief counsel is the primary attorney and everything, and you send the ACCs around as non-primaries. So if they're not going to let us know who the ACCs are, then we're just going to just bombard the chief counsel.
I think what's going to happen. Chief counsel will say you need to go to the duty attorney.
But Cleveland doesn't have a duty attorney.
Oh, okay.
They don't. They have rotated.
So we would rotate. So we would be assigned it at least once a week.
At least you have an email, or we were not even allowed to email Cleveland, right?
Yeah.
Right, Rob?
Yeah, there's no email for Cleveland duty attorney.
There's no duty attorney email?
No.
Oh, so Charlotte has a duty attorney box. And
most courts do.
There's two different ones. There's ones that you can email as an attorney, which they set up in probably 2022 or 2021. So that was a new thing, because every once in a while a private attorney would get the other duty attorney box, which was really meant for the officers, for our so-called clients, like the officers, ERO and HSI, Homeland Security Investigations. I know you guys know this, but anyone else watching it, and enforcement removal operations. So that was a separate duty attorney box. So we finally set up one for the attorneys, which I think is great, because now myself as an attorney, I can write to that box and find out what's the status of a motion that's been pending for a while, and they'll send it to the assigned attorney. So that assigned attorney will more likely get back to me.
Yeah. Well, and the inability of the defense counsel to be able to communicate with the assigned OPLA attorney, I mean, that just puts more burden on the judge.
Yeah.
When the sides are coming into court and just basic things like, are we contesting identity? Are we contesting, history or entry date or the 1 year on asylum? If those things haven't been resolved by the time they come into court, then, I've got a 2-hour trial block, or maybe a 3-hour trial block. I got 3 trials that day, and I've got to spend 20, 30 minutes.
Mm-hmm.
So it creates huge problem. And one of the biggest shocks to me when I first took the bench was the complete lack of legal support, and it's the same for the OPLA attorneys as well. But as far as law clerks and that sort of thing, we at our location we had 5 judges and technically 2 law clerks to help with legal research and things and writing, but one of them was on duty in Washington, so one.
You have to shoot
So
that clerk.
yeah, 5 judges with one law clerk for. So you need the research, the writing, anything like that. You're doing it on yourself, but that's after being on the bench all day because arraignments or master calendars and then trials and whatever.
Yeah,
So it's
that's ludicrous. They definitely went down on the law clerks. The same thing in Boston. I heard that, Judge Pappas, former Judge Pappas that we had on here, George Pappas, said that he shared a law clerk with many judges too.
yeah.
So
So I
he
mean,
was
I just
working
you
a
just
lot of
do it
nights
on
and a lot
yourself.
of nights.
Yeah, and so it's and now with the imposed guidelines, the case completion guidelines. And I don't know if you've read those recently, but the some of the guidelines are like 95% of detained cases completed within 60 days is their target.
Well, I don't
And
understand. You get due process in 60 days.
well, and people don't understand too that if you're detained, there's no interpreter. So if you're detained and you've got to file your asylum application, you've got to sit down with whatever Spanish to English dictionary you can find in the law library or whatever your language is, and try to fill that out on your own, and then still complete the case within 60 days.
And
There's a lot of due process problems there. Those things are just going to drag out in the appellate court for
yeah,
forever as to whether or not that's a
they're
legitimate due process.
they're subject to the Real ID Act, but trying to get some of that Real ID Act material in 60 days from another country while you're detained
Exactly.
is, again, ludicrous. Like, it's just not fathomable. Like, just getting it through customs alone may take time, depending on
Yeah.
how you're sending it, what country it's coming from.
Yeah. Yeah, or if you're detained, just even simple things like your medical records from, because you know how jail mail works. I mean, jail mail's it takes a week for it to leave the jail sometimes.
With
So
jail mail, like, I really got some experience in Cleveland, by the way, on a federal case. They wouldn't even I sent a thumb drive to a former client, and they returned it because they were so antiquated. They still want a CD, which I think a CD would be more dangerous. Like, you could cut people with that, but so you also have to find out the rules of that particular Bureau of Prisons if you're dealing with the Bureau of Prisons, because just trying to get stuff back and forth to your client, it's very difficult.
yeah, and because my background was always criminal defense before I started doing a lot of immigration work, and I did a lot of post conviction and habeas and things like that. And yeah, I mean, it takes time, and in federal court, a habeas can take years. I mean, legitimately can drag out for years, gathering evidence and all that. And they're going to try to complete these cases in 60 days. So we should probably talk about the other big news that's going on these days with all the U visas
Oh,
and the
yeah.
indictments. And I know I've talked to some people recently that have fallen victim to this, and it's
And add one
interesting.
more thing to Annis is saying. Annis, I agree with Rob that I think the judges, whatever judges you're dealing with, are, well, I think all the judges around this country, but are scared for their jobs. So
Yeah,
I don't
100%.
blame them.
you mentioned the word FBI. That alone, even though I hope, I mean, today's day and age, it doesn't have the same prestige because of things going on in the news. But that's got to probably scare them that the administration is making that a priority case and, their jobs could be lost like that based on whatever. Was it Article 2 or 1? Article 2, he was saying, right? Just fire people at will.
Yeah.
So I think they're just being cautious.
Yeah, the judges are going to be very cautious. I don't think there's any question about that.
Until this pressure goes away. Okay, back to the UVs.
Well, no, yeah. For everybody to catch up, I mean, obviously back in July, there was the indictment, the shares in Oakdale, Louisiana, which is also the home of an immigration court, were selling U visas. And lots of them, apparently.
Who was selling them, Rob?
Well, that's who's selling what? I mean, it's interesting because the shares were being paid.
Who signed
What's
off?
that?
Who signed off on the law enforcement certifications?
Yeah, that's it. The shares were being paid to sign off on the law enforcement certification.
Sheriffs, yeah.
Mm-hmm. Yeah, and they were being paid by, apparently, according to the indictment, a local businessman.
I think they're claiming they only were given $1,000, but I think they don't know that everybody that I've talked to, that I'm representing, stated that they gave the person arranging the whole thing. Depends on which person you talk to. Like one said 20,000, others said 30,000, some said 30,000 for each person. So if they had 2 people, that was $60,000. So I don't know if the sheriffs got more than they said, but the arranger definitely made like $1 million off of the whole thing.
Oh, easily. The thing I find interesting about all these indictments so far is that I haven't seen any attorneys indicted yet. But, I mean, there's been a number of attorneys get indicted for this kind of shenanigans in the past.
But it's interesting you say that, because one of the attorneys that one of my clients went to, they were notified and they immediately terminated the agreement with the client and sent them a closeout letter. And you could tell that attorney was very professional and I'm sure did not know that, what was going on. But another attorney, I've seen that name a lot before, and I won't say who it is, but it's an Indian name. And I don't know, but if there's some way if you knew and you were the attorney, there's a problem there.
Yeah.
Obviously.
Yeah. Well, but it's happened. I mean, we've seen it. There's a large marriage fraud, Invawa fraud case out of New York, I think just last year. A couple of attorneys got indicted up there, and there was a Russian case up in New York last year as well, or 2 years ago now, I guess. So it happens. So, but the issue, I think, and I've talked to a lot of the people that were the beneficiaries, if you will, of these U visas. They were the people that the U visas were signed off on, and now they're in a very precarious position. They may have had some form of relief, or they may have been in some sort of status before, but now they're in a very, very difficult situation.
They're in a very difficult situation. I'm glad that the ones that came to me because, I need to get all the truth out of their situation and how they got into this predicament. And based on what I've talked to with them, I won't give too many details, but basically I believe that these particular people that I've spoken to were victimized. And I'm not excusing the U visa part, any part they knew about. And in fact, of course, they're willing to help law enforcement in any way they can in that. But I do understand how they were exploited from the moment they were recruited to come here to work. They were vulnerable. They were human trafficked. They paid $90,000 to get to the United States. Some paid $45,000. Today they pay $90,000 US dollars. They borrow the money from friends, family, sometimes loan sharks. They have to repay that. They get into forced labor situations. and they get exploited by their own Indian community. And then if they don't have status, they feel like they can't do anything to basically rectify the exploitation unless they can get status. And I think that's how a bunch of the people that have come to me ended up in this precarious situation. And now they look like they're liars. And that's what scares me as a former government attorney, is they look like, I know how it looks like when you're government. Okay.
Yeah.
You lied here. How do I believe you over here? So I have to make sure I tell the complete truth in their TV's story about their journey here, and make sure they open up to me about, because sometimes they, they're loyal to their employers to a fault. They don't want to talk about it. So I need them to talk about it, and I need to pull out the lack of overtime pay, the lack of paying them sufficiently. And
You know what's so interesting is 90K. Wow. If we wanted to come up with 90K in like 1 second, it would be so difficult. I have a lot of clients who just still say is, geez, we wish we never came because America's expensive. Everything was hey, it is what it is, but it's interesting. But the border numbers have significantly dropped, haven't they?
Yeah.
To almost zero.
Yeah.
Yeah. Yeah.
Which I think is, what's a shame, I think, and it really breaks my heart, is that there's so many people that have been here for so long
Yes.
that could qualify simply through, lowering the standard for cancellation of removal, to not make it unconscionable, or fixing the I-601A waiver so you could do it from, a parent to a child to a parent. There's some simple fixes that can really deal with, a lot of the problems
Yeah.
for so many people through the legal process,
Well,
and
my
now we're
favorite-
just in a situation where they're just
Yeah.
like today they didn't end up detaining them, but they're just detaining everyone and deporting everyone. It's just not even, it's not even it's almost like, throw everything with the bathwater, right?
Yeah. Throw the baby out with the bathwater. Yeah.
Yeah. My favorite fix to many of the problems is just if they bring back the Life Act. If they bring back 245I,
Oh,
I
yeah.
mean, how many problems does that solve?
Or registry, do the registry.
Oh,
Yeah.
yeah. Registry is so, oh my God, that date of, what is it, 1972, or is it still before? Like that date has been there, I think, since I started as a government attorney.
Mhm.
Or if they just would grant deferred action, give people work permits. We're not saying get the legal status until you can figure everything out. The border's kind of secure now. You figure out what happened over the last, 4 years right now with all the people coming in with no status. I have so many calls, and look, I'm honest with people. I'm like, look, if I was a crook, I'll just take your money. But you've been here for a year. You have no status. You're from a country that has no problems. I don't want to take your money.
Right.
I don't want to promise you something or anything. The most I could do is get you a voluntary departure, but you can get that yourself.
Yeah.
These
Well,
are people.
that's something that a lot of people, I don't think, understand is um, the potential pathways to try to get to a lawful status, and they look at it like, I'm here, I should be able to accomplish something, and that's not necessarily the way it works.
There's not a lot of pathways, that's why after doing this for like 26 as an attorney, but being in this INS arena since 1992, I sympathize in a way, and I know entering legally is, wrong. I get that, but once they get here and they are in the country and they become part of the communities and their kids are going to school with our kids, and there's not a lot of ways for them to get in status. And the ways they did have, like when 245I, the bakers could go in and they could then get the labor certification, and they could be sponsored as a baker. Even if they're working for Dunkin' Donuts and baking in the back the donuts, they can't do that today. And even if there was a 245I, the waiting time is like the visa bulletin is so far out.
Oh, marriage visa, 18 months to process a marriage visa now.
Yeah.
I remember, and it's not been that many years ago that, I'm old, but not that old, but it's, you get a
6
marriage visa.
months.
I've seen some that I turned around in 30 days,
Yeah.
and
I have
not
and it's
more.
like I'm to file a mandamus because he's an 01 and his 01 is due to expire in February. And I put in the I-130, very legitimate marriage, tons of photos, tons of evidence. Guy's from Australia. I mean, he
Mhm.
fits everything that Trump wants, right? He's white, but his, it's been pending way too long, but he can't even get his CO9. Like, why can't he get his work authorization in a timely fashion? I don't want him to be working.
Yeah.
He's an 01 ballroom instructor. Like, he was one of the top in the world ballroom dancers. And he has classes to teach. And in February, when his 01 expires, he should have his, work authorization already from the CO9. He should have already had it. And I keep hearing people in the Charlotte area say that they're filing stuff 6 months ago and they're getting approvals. But I have stuff filed a year ago and it's just sitting there.
Well, and I don't think there's any rhyme or reason to it anymore, because I've seen the same thing. I've seen things filed soon that come back with no problems, and other things that have been laying there forever.
I noticed also work permits are being delayed. You'll get an approval, and it used to be like a week, you'll get your work permit or green card. Now I got some, it's been a month, and we still haven't even sent out the card for a work permit or green card.
How long is it taking you to get a work permit when you file the 485, like to get the CO9?
Well, it used to be like 2.5 months, but now they're just pending. Like, I had to do an expedite because one worked for a defense contractor. So, he was TPS Syria. So he was literally now he's freaking out because I got the expedite and I got the approval, but it's been 3 weeks and he still doesn't have his work permit.
How'd you get
And no mandatory extension, no automatic extensions.
Well, here's the thing is about Syria that's really messed up is that they missed the date. So technically, you're supposed to be under the regs. It's supposed to be 6-month automatic extension under the regs in the statute, but they didn't even do that. They didn't even do their homework on it, and nobody's even challenging it. And it's cool for him because he has an EB2, but the visa waits out. But luckily, he got married. So we filed it for him, and the only way I could get the best way to do it is I realized I don't even bother with cover letters and attorney letters. I said, nah, go get a letter from your defense contractor, and I go to the online account and I do a inbox message expedite, put in the information, I upload in the unsolicited evidence just the letter, and I leave it be, and boom, it's approved. But when I write something and I make it, very professional stuff, they just don't even look at it.
Okay, that's true. So tell me, Ennis, where are you putting that into? Are you doing it are you putting in like, I have a question about a pending application, and then you put in?
No. So what you do is first you upload an unsolicited evidence.
So you
at the I-765, you upload whatever the expedite is. Okay. Then you go to your inbox and you do new message, and you choose that case, and there's an option for you to put I want to expedite this case.
New message.
Yeah. So if you go to your UCS account, go to inbox.
Okay.
And once you go to inbox, you'll have an ability to choose a case and do a new message, and there'll be ability for you to do expedite. So you put in the expedite request there, but in your unsolicited evidence needs to be the expedite. They'll review it.
And your unsolicited, so it already, put that in there first, and then, and not just.
Because it'll ask you when you do it in the message, it'll say, did you upload the evidence?
Okay. And you're not even doing the whole cover letter thing you said. You're doing like just, so if I get his employer, for example, from the ballroom dancing place, if I get them to write a letter just saying that he needs to keep his work authorization, he's got classes to teach. I know yours was a defense contractor. It's a little more. But
no, and they didn't even say much. I mean, just what I would do is just upload the letter, put it in there. I feel like, unfortunately, now the more lawyering we do, the more they push back and don't want to deal with us.
Yeah, and I think just the fact that they receive something puts it on somebody's calendar so that it or somebody's desk, and so it gets dealt with. Otherwise, they've just got this big pile of things that need to be done with, and
Right.
they just take them as something pops up.
I had to push an officer while the officer was like transcribing for the supervisor. Like literally, she sat on a case for like 2 months, and I went to her. I was like, "Yo, come on, please, yo, you promised me like in a week. There's no problems. The client is really mad at me for no reason, and I really want to get paid, right?"
Right.
So right, and then she looked at it. She got approved. It came and got approved, and now like the green card's stuck. So I think Rob's right. It's not their fault. I just think they're overwhelmed.
Yeah,
They're not doing it on purpose.
Oh,
yeah.
no,
If something
no,
shows
no.
up on their screen, they'll deal with it right then and there.
I mean, I really wish I knew the numbers of how many people they lost during 2025 at USCIS, like at each office, each service center, because the backlog seems to get worse. And they seem to be working on the cases that come first sometimes randomly, or maybe everybody's putting in this on, they're doing the expedites and I just don't know it, but
Yeah, I just don't envy them. And the sad thing is it goes back to, I mean, every time somebody comes in on CBP1 and they charge them with, not admit, they charge them with no valid document.
Mm-hmm.
I always challenge it. I'm hoping one day to take it to BIA, because look how kind of like terrible this was. Under the previous, and again, I'm not political. I don't care either
Yeah.
way. But I just look at it from a lawyer. And as a lawyer, you think about these people, they come through, they literally advertise, they used to advertise on the website, come in and you'll be able to travel to the United States. They bring them into an interview, they give them a 994, and then they immediately put them in court.
Wait.
Like,
wait, okay, they were immediately.
that's the CBP1.
That's the ones for the ones that got granted to come in for 2 years, like the Cuban.
Yeah, they were automatically put into court for no valid document, even though they basically. So I didn't know if it was on purpose or what, but you basically lured these people to come here. You told them there's a lawful process to go through CBP1. You grant them parole and getting them a work permit, but at the same time you put them in immigration court, and usually they don't have much.
Yeah, the administration changed, so your invitation gets revoked, and now you get thrown into this.
Okay, it's the new.
This
But
process.
but even the previous administration, think about what they were doing.
They did.
They were putting them in court. They were inviting them here on CBP1, paroling them in, and immediately putting them in court. That's not even this administration. That was the previous administration.
Yeah, but they were giving them work authorization, and those cases were on a track that wasn't going to take a decade to process. Now they're
overwhelmed the system.
Oh, it overrun it. That doesn't make any sense when the court's already backlogged, because they were given the permission to come in. And most of those Cubans, if they're given parole, they're eligible for the Cuban Adjustment Act. And
yeah, that's the best thing. Yep. I mean, like I have one now. I had to do a motion, but they use notarios a lot. They use notarios a lot, and they don't know anything about court, and they tell them don't show up to court. And I had a poor, sweet, amazing woman. She was so nice, and she's a little disabled. She's deaf and everything. And this notario literally told her not to go to court. She misses her court, gets an abstention order. But I was able to find a Ninth Circuit case that I relied on in the Second Circuit. I'm in the Second Circuit in this case, but it was a Ninth Circuit case that said Lazada on notarios. And the way you do it is I had her complain to EOIR for and provide everything, and because there's no place to really complain about them. They don't have a bar association or anything like that.
You can make a UPL complaint. And that's what I've done in the past. Is I've had the clients make a UPL complaint to the state bar, and I submitted that.
Yeah,
well, that would work. But I did the EOIR and it worked somehow. But there's a great Ninth Circuit case on notarios applying the Lazada standard. And it was interesting because the judge she had a paid attorney. So I had to do a fee waiver because originally when we did it, it was $100 and whatever dollars. And then by the time we were filing it, it was like thousands of dollars, and it was like the last day. So I said, whatever, let me do a fee waiver. And then, worst case scenario, I get the cure period, right? And with the new BIA decision, it says, basically, unless you're detained and have like a pro bono attorney, you're not getting a fee waiver, but
Sure.
somehow he granted it.
Oh, well, that's good.
It's a good
Because
argument
it's
on
just
your
crazy that you have to pay all these crazy fees now just for a motion, especially if it's a motion to fix an error they did. I mean,
But she still has a problem.
yeah.
She still has a problem because she missed the hearing.
Well,
So I have to now argue she's not inadmissible for missing for failure to attend removal proceedings, even under the Cuban Adjustment Act.
that's the $5,000 fee too, right? For an in absentia.
No, I don't know. Is there a $5,000 one?
Okay,
No, it's
I
like
didn't know.
10,
But I remember when they were
1065,
first.
something like that.
It's how much?
Isn't it 1,065?
It's like 1,000 something
Yeah,
Okay, that's
1,080.
for an absentia.
it's just
Weird number.
But I mean, worst case scenario, you do if you're really under the clock and they don't have the money. Because my argument was, listen, Your Honor, like it'll take her like 3 or 4 months to come up with that $1,000.
yeah.
So, what do you want to do? You want her to miss the deadline for the absentia and then it can't do it, and he accepted it.
You know what? That's true.
That's excellent.
That's my argument. My argument is, yeah, she can come up with it, but it'll take her 3 to 4 months. But the problem is, she'll miss the deadline.
See, I think the people, when I went to Congress for ALA, for the National Day of Action, I feel like they actually took my advice to hand on some things, but they misapplied it. Like I told the senator's office from South Carolina and the representatives, I said, that we could actually supply and demand, right? A lot of people want to come to the United States. The law of supply and demand, we could actually pay off the national debt. But here's how we do it. We could charge more for visas, and to come into the United States.
Or deferred action and hire the EAD.
Mm-hmm.
Yeah. So I told them, and then say the $90,000 that people pay to come to the United States, which I didn't know it was up to 90. I knew 10,000, right? So I said, if they're paying $10,000 to the cartel, they would love to pay $10,000 directly to the U.S. government and get a visa to come right here, to come work at a gas station. No one wants that job. No one wants to be working overnight in a gas station in a poor neighborhood. People aren't competing for that job. Let's say that is true, which I believe it is, but let's say that's true. Then why not, instead of having them come illegally, have them put in for this visa, pay the 10 grand instead to the U.S. government, because they're going to pay it to the smugglers. So pay it to the U.S. government, and it helps pay off the debt. But then the fees that I see they're charging, I'm like, this is not what I said. I didn't.
Or how about the people that, listen, they have an approved I-130, but it's from their kid. Let them pay some money and go through the process. A cancellation of removal process. If the argument is we don't want to provide them a green card and citizenship because they came in illegally, that's fine. But there's so many different ways of the law. The parole in place, for instance, believe it or not, I thought that was a good idea.
It's a great idea.
It was really a good idea because you got these people that are stuck here. Why do we have to send them back on I-601A and it takes 3-4 years and they're sitting here for 4 years anyway? It doesn't make any sense.
None of that makes sense.
If you meet the good moral character qualifications and all that, I mean, it's going to bring out of the woodwork the people that we would want to be here.
Yeah.
And that's just that. Let them wait for the visa. That's fine. But they get a work permit and they can wait for the visa.
Yeah.
And even if
to your point, anytime there's
Go ahead, Mark.
Well, no, but to Anas's point, anytime that there's conversations about immigration reform, it's always all or nothing. It's citizenship or nothing. And it doesn't have to be that way. There's so many, I mean, even, I have a withholding trial coming up this week. I mean, you can do something like a withholding, which means that you get to stay and that's it. You don't get citizenship. You don't. And if you screw up, you're out automatically because you have a removal order, before you're granted withholding. So, I mean, there's all kinds of in-betweens that could solve a lot of problems.
They can add things to that, it's a compromise where you only get withholding because this type of withholding, let's say it's not even based on country conditions, but you get a form of this type of withholding and removal. But if the next 10 years you can establish that you have paid your fair share of taxes and put into Social Security and Medicare, then you can put in for something to bump it up to something else, because you're now showing you're contributing to the economy. And I know the people who are super poor, that's going to, but even when you're super poor and you're working, you're still contributing to the taxes and the Social Security and the Medicare. And if that's what they're worried about, is these people aren't contributing to Medicare, Social Security, and they're just depleting things, well, then have them at least pay back taxes for the last 3 years and allow them to pay the 1,000 super penalty for like 245I, bring it back, and have that money go to the national debt. And let's start wiping out this debt instead of making more debt by, on us.
Yeah, we lost him. Well, and that's it. There's just so many pathways between, it's not all or nothing. There's just a multitude of ways, but nobody, and I don't think politicians understand it. And clearly, the talking points are on opposite ends of the spectrum. So there's nobody that has good understanding of anything in the middle. Like people like us that have been doing it for a long, long time. It's the option. Well, since we lost Anas, I'll go ahead and throw you off too, and we'll all say goodbye. See you next week. When you got the habeas coming up next week, give me a call.
Next week, yeah, I will.
To help you.
Yeah, definitely.
All right. We'll see you.
Good seeing you.
Bye.